Good morning, everyone. Welcome back to the page. Welcome to another training video. Today we're going to spend a little bit longer together. We're going to discuss the most common used contract that we use in our industry and our business. There are hundreds of documents that we're expected to be experts on. This one is absolutely one you need to spend the extra time on. Take your time, read it. As we go through this video, go ahead and print out a blank copy of it. Take your notes, have a notepad, write down questions, get with your broker, get with the senior agent, get with someone if they're over your training department, and ask your questions because we need to know this contract inside and out. The one we're talking about today is going to be the 1 to 4 family residential contract for resale. Right off the bat, when you look at it, a lot of people 1 to 4, 1 to 4. What does it mean? What's the purpose of this contract? That doesn't mean if there's 1 to 4 family members living in the house. It's 1 to 4 family residential property. So we're talking about single family homes. We're talking about duplexes, triplexes, all the way up to quadplexes would be on this contract. They put a couple of notes on here for you, right? It's a resale contract. So if we're talking about new builds, land home build package won't be used on this contract, and then right underneath the heading, the notice not for use with condominium transactions. If it's a condo, it uses a separate contract also. There's multiple contracts. There's condominium, there's commercial, there's farm and ranch, there's unimproved property. But if you're dealing with a home or a duplex, a triplex, or a quadplex, this is the contract that'll be used. The majority of them are single family residents. That's why that's why this contract is used so often. But about a 12-page contract, a lot of information, right? We cringe a lot of times. You hear agents go, well, I sat down with them and they read every page of the document. That's okay, right? What they're signing is committing them to a whole lot of requirements and expectations. So we need to take our time. We need to read through every piece of this contract. There's a lot of stuff in here that people don't pay attention to. There's a lot of questions that asked about, well, does the refrigerator stay? Well, what does the contract say? Right. This is a binding document once signed by both parties, executed. We are part of a binding contract. You can't just make another contract. You have to do an amendment to change the contract. You have to terminate this one if you're going to do a new one. But you need to be knowledgeable about the information inside this contract. So here we go. 1 to 4 family residential contract resale. Paragraph 1 is the parties, right? The parties of these contract. Top line is for sellers, bottom line is for buyers. This needs to be their legal name. Whatever name will be on title, right? You go by Steve, but your full name is Steven. You need to have the entire legal name for one, both, multiple parties, whatever the situation is, needs to be there. Same on the seller side. The seller side, what is the property titled into? Good place to look is the appraisal district. If not sure, ask for a copy of the deed. Title can help you with this also if there's not someone in your office that can, but this needs to be legal names. Paragraph 2, this is where your property goes. Land improvements and accessories are collectively referred to as the property. So what goes in paragraph A? Lot, block, then you have addition, city, county, known as. Lot, block, when you studied for your exam, you actually studied this. What are surveys? What are abstracts, right? If it's in town, it's probably going to have a lot block. The deed will have this. The appraisal district, you can find it on there, right? Lot, block, and the subdivision. So lot 3, block 9 of the Big Oak subdivision. That's one we have here. We run into a lot here in town. But if there's not a lot block, you will put the legal description here. 7.32 acres being part of whatever survey, right? Again, same place. It's on the deed. It's at the appraisal district. This is where your legal description will go in this field. What city we're part of, what county we're part of, and then known as is the physical address. Does it have a physical address? Is it a to be determined? But the next blank is where that goes. We get that filled out, we go over it with our clients, and then we blow right through B, C, and D. These are important sections, they're important paragraphs to go through. What are improvements, right? The house, the garage, all fixtures and improvements attached to the property, they go with the property. If any, all equipment, appliances, valances, screens, shutters, awnings, wall-to-wall carpeting, mirrors, ceiling fans, right? You can't go in and pull ceiling fans out just because you like it. Unless you disclose that, unless you put it in the exclusions, any fixtures go with the property. This is built into our contracts. So people ask, well, does it go? If they didn't exclude it, it goes. So make sure you touch on that section with your client. Accessories are the exact same way, right? They can't take the gas burning logs out of the fireplace. That is considered an accessory. It's supposed to go with the home security systems, garage door clickers, all the keys. They're considered accessories. They belong to that home. They stay with that home. And then paragraph D is your exclusions. The following improvements and accessories will be retained by the seller and must be removed prior to the delivery of possession. If they're going to keep the refrigerator, it goes here. If there is a light fixture above the dining room table that John Doe's daughter built for them or bought for them and they want to take it with them, you can put that underneath the exclusion. These are items, fixtures or accessories, not personal property, but fixtures or accessories that should stay with the home. You can put them here as an exclusion. This conversation needs to be had at the very beginning. This should be had at the front end of either the listing, especially the contract process, to make sure that there's an understanding that these items are going to be removed. If you're going to pull a ceiling fan down, yes, tell your client they're going to have to put another ceiling fan up. They can't just leave a hole in the ceiling, but they can exclude it, reserve it here in section D. E is reservations, all reservations for oil, gas, and other minerals, water rights, timber, right, any of these interests. But if you read, it says interest is made in accordance with an attached addendum. So many things that relate to a transaction, there's an addendum for whatever that is. Mineral reservation is one of those. You will use a separate form attached to the contract that will reserve their mineral right, whether they're reserving it all, a partial, reserving rights of ingress and egress. There's a separate addendum for that. We've got a lead-based paint, we've got a seller's disclosure, we've got right to terminate due to lender's appraisal. There's several addendums that will be used in conjunction with this contract. So then we go to paragraph 3. Paragraph 3 is the sales price. This is what they're going to purchase the home for. There's 2 sections. Does the math for you, but cash portion is the top. This is if it's an all cash transaction. They're going to buy the home for $150,000. That's what you're going to put here. Paragraph B is if there's financing. So if somebody's going to pay $300,000 for a home, they're going to put $150,000 down and they're going to finance $150,000. Both amounts will go in here. So you've got $150,000 cash portion. This is the down payment or all cash if they're purchasing cash. And then you have a couple of options here: third-party financing addendum, loan assumption addendum, or seller financing addendum. Third-party financing is by far the most common addendum that you will use. This is if they're using a lender, whether it's a private lender, local bank, mortgage broker, right? Fannie Mae, Freddie Mac, FHA, VA, all of that will be on the third-party financing addendum. Loan assumption, this is if somebody is being allowed to assume somebody's note. A lot of moving pieces to that. Doesn't happen very often, but there are a few of them out there. And then seller financing addendum has its own option. This is where the seller is going to carry the note for the purchaser. But cash portion, finance portion for your total sales price. Paragraph 4, except as disclosed in this contract. Seller is not aware of any leases affecting the property. Did somebody have some land, some of the couple of acres that goes with the house leased to somebody for cattle? Is it a written lease? You have to disclose that, and you have to provide a copy of that lease. Does it have natural gas leases, oil leases? Is the property already leased and in production? If so, you have to disclose that. You have to provide a copy of those leases. And then you have fixture leases, which is they have a security system in the home that's under a 12-month contract. We just did one that's a 36-month contract. You have to provide the details of that, provide a copy of that lease agreement to the sellers, to the buyers. Sorry. Page 2. Dumb little fact, but the top box, again, this is something that is missed so common. The address goes up here, says it in parentheses, but this is as a broker during compliance, this is a field that's missed a lot. Once you fill it out, if you're using zip forms or all DocuSign, once you populate it in the first top of page 2, it fills in the rest of the pages, but just make sure it's there. Paragraph 5 is your earnest money and termination option. Delivery of earnest money and option money within 3 days after the effective date. Buyer must deliver to, and this is where we get to pick our title company, right? Earnest money, option money, title company, and option length is all negotiable, right? Have these conversations with your client. They can offer whatever they want. 1% for earnest money is kind of the standard numbers, been the standards, what people have used, but it is negotiable. Earnest money is just kind of giving validation to your offer. I'm serious about this. I'm willing to put some money up towards the purchase price to get this home under contract. Option money, the contract is full of outs, full of terms that the buyer can get their option money, their earnest money back. There's reasons they wouldn't, all throughout, and we'll walk through those. But earnest money, option money, who's it going to, what's their address, and how much. The earnest money at closing gets credited back to their cash to close, so they don't just give it to them and it goes away. It will be credited back. So if they put $3,000 down as earnest money, they're supposed to bring $15,000 cash to close. They're only going to have to bring $3,000 because that $3,000 is going to be credited towards that. The next blank after the earnest money says and blank as the option fee. Again, I've seen everywhere from $50 to $1,500 for an option period. What an option period is it gives the buyer the option to terminate. It's called an unrestricted right to terminate. So they don't like the colors of the wall, they don't like the smell in the house, something like that. It sounds dumb, but what it really is for is gives them time to do their inspection, to get the inspection back, make sure there's nothing major, right? We're looking for anything and everything. Me personally, I'm looking for foundation, I'm looking for plumbing, electrical, roof, any big ticket items that could really put somebody in a bind if they're strapped for cash. This is where your option amount goes, right? The earnest money and option money will be made payable to the escrow office, the escrow agent. It goes to the title company. It can be paid separately or in one payment, and it has to be paid within 3 days. This is 3 business days. If the third day falls on a weekend, you have until the 5 o'clock the following business day that the escrow office is open to get this money in. Again, it explains that to them. Paragraph B is your termination option. How long, right? For nominal consideration, this is the amount that's up here in this blank. Whether you put $150, how long does that purchase them, right? The receipt of which seller acknowledges and buyer agreement to pay the option fee within the time required, 3 days. Seller grants buyer the unrestricted right to terminate this contract by giving notice of termination to seller within, most common we see is 7 to 10 days. When the market was really crazy and hot, we were doing 7. We were doing even a couple of 5-day option periods, trying to get stuff done, making our offer more aggressive. But what we see commonly is 7 to 10 days. That gives them time to get the inspectors, the appraisers, whoever they're wanting to view the property. Gives them time to get them set up, and get the reports back and go back in and renegotiate or ask for repairs, whatever the situation is, depending on the results of those inspections. Everything goes off of 5 p.m. at the end of the day, the business day. If I have until 5 o'clock this afternoon, today's the last day of my option period, and I wait till 7, I have voided that option period. Dates, times, deadlines matter. That's why every bit of it is spelled out in this contract. It's why you need to understand and know those deadlines inside your contract. All right. Then we talk about what people have the ability to do if the contract obligations are not met. All right, paragraph C, failure to timely deliver earnest money. If the buyer fails to deliver the earnest money within the time required, seller may terminate the contract or exercise the remedies under paragraph 15, or both, by providing notice to buyer before buyer delivers the earnest money. Right? Time is of the essence. You're going to hear that term over and over and over in this business. What that is saying, and what paragraph C is saying, is if they don't deliver the earnest money within 3 days, I can, as a seller, I can terminate the contract. I have to notify them in writing. But if I don't notify them in writing before they show up 6 days later and put the earnest money, I didn't exercise that right. Right? Now, failure to timely deliver option fee, if no dollar amount is stated, or if the buyer fails to deliver the option fee within the time required, you don't get an option period. You have to purchase this. So 3 days comes, you did your inspections, ends up something popping up on the inspection report and you want to back out, but you never took your $150 option fee to title. You don't, as a buyer, have that option period. You don't have that right to terminate, unrestricted right to terminate. So your earnest money is at risk. If you walk away from the contract, the seller could keep your earnest money because you didn't meet the obligations of the contract. And he talks about time is of the essence. For this paragraph specifically, but most of the contract we operate underneath time is of the essence. Paragraph 6, title policy and survey. Again, very negotiable. This is one of the pieces that we negotiate in a contract regularly. Paragraph A is about the title policy. Seller shall furnish the buyer. Right? Seller has to provide the buyer. Now, at whose cost is in the next one. I have seller check. You can negotiate who is going to pay it. They can split it. Most common is probably seller paying for the title policy. And then the title insurance policy issued by, this is the title company that you're using as your escrow. Every now and then you'll have a one-off. We closed a few at attorneys' offices, and we have a separate, he's held escrow, he's held the earnest money, he's held the option fee money, but a title company has to issue the title policy. So that information will go in here. Paragraph B is the commitment. It talks about within 20 days after the title company receives a copy of this contract. So I get it signed, I get it executed, and I wait a week to send the contract to title company. This clock does not start ticking until I deliver it to title. Right? But within 20 days after they receive a copy of the contract, seller shall furnish the buyer a commitment for title insurance. And at buyer's expense, legible copies of restrictive covenants, documents evidencing exceptions in the commitment, other than the standard printed exceptions. Right? Seller, by signing this contract, seller authorizes the title company to deliver the commitment exception documents to buyer at buyer's address shown in paragraph 21. If they're not delivered within the specified time, so our 20 days, if we don't get it to them, title is not efficient, they don't meet their time. But if it's not to them within the specified time, the time for delivery will automatically be extended up to 15 days or 3 days prior to closing, whichever is earlier. If the commitment and exception documents are not delivered within that time required, buyer can terminate the contract. So if title company just drops the ball, we don't follow up with them, we don't make sure it gets provided to the buyer's agent and the buyer, we can miss deadlines and buyers have the ability to terminate the contract and their earnest money be refunded. This is pre-printed, it is part of the contract, it is in there. Read through it, understand it, be able to have conversations about it. Paragraph C. One of the most straightforward paragraphs, but one of the most common issues that I see from my time as an agent, but also as a broker. So when it comes to surveys, you have 4 options, right? 1, 2, and 3, and the 4th option is you don't select any of them. Right? The survey must be made by a registered professional land surveyor, acceptable to the title company and buyer's lender, right? Who's going to pay for it? Who's going to provide it? That's what your options are. The first option is just not select it. They don't need a survey. Lender's not going to require it. Title can insure the property without a new survey. We're good to go. You don't put anything, nobody's getting a survey, nobody's paying for a survey. All right? And then you've got paragraph 2 and paragraph 3 within how many days? Right? Don't put 4 days, because a surveyor is not going to get it done in 4 days. 14, 21 days, call your surveyor, have a relationship, ask them, when can you get it back to me, before you populate how quick you can get the survey to them. But within 21 days after the effective date of this contract, buyer may obtain a new survey at buyer's expense. Or 3 is seller at seller's expense shall furnish a new survey to a buyer. There's not a survey, we can't find it, things have changed, we need a new one. Is the buyer going to pay for it? Is the seller going to pay for it? More often, you use paragraph 1. Within 7 days after the effective date of this contract, seller shall furnish to buyer and title company seller's existing survey of the property and, there's an and a residential real property affidavit or declaration. Right? What we call a T47. So if this box is checked within however many days, 7 days, seller is going to provide a copy of their existing survey with a T47, which is stating that if anything has changed with the property. If this box is checked, make sure you as the seller's agent provide this to the buyer's agent. Because there's actions to be taken if not provided. Right? If you're taking a listing, ask them right off the bat, do you have a survey? If they do, get a copy of it. Go ahead and get a T47 done so this can be taken care of. You can upload it to Associated Docs, but I'm still going to send it to the buyer's agent once we go under contract within the dates that are in this contract. This one's defaulted to 7 days. Because if you read, this used to be bold. They took this out when they did some changes to the contract, but more agents have had to purchase a survey because they don't pay attention to this line. Buyer shall obtain a new survey at seller's expense no later than 3 days prior to closing if seller fails to furnish within the time prescribed both the existing survey and the affidavit of declaration. You have the survey, you have the T47, and you send it to them on the 9th day. The buyer has the ability, because of what is signed in this contract, to order a new survey and bill it to the seller at closing. Whether you had one, whether you just forgot. So absolutely make sure you have the survey, make sure you have the T47 before you let your client sign this section, and make sure you provide it. Because if not, they're going to order a new survey and your seller's going to pay for it. All right, everybody jumps down to this next section. It says if the title company or buyer's lender does not accept the existing survey or the affidavit, buyer shall obtain a new survey at, and we have the option of seller or buyer's expense. So this says buyers most of the time. What this is saying, that if it's a 60-year-old survey that's not valid anymore, or it's too old, things have changed, and title will not insure on that, or the lender doesn't accept it, this is when they default to who is going to pay for the new survey that is required. But if you don't provide it, they automatically get to order a new one at seller's expense, no matter if buyer is checked in this box. Read through this, study this, listen to this part of the video again. Make sure you understand paragraph C1. It will save you a lot of heartache. It will save you some upset clients, because you understand what their obligations are with C1. D is objections. Buyer may object in writing to defects, exceptions, and encumbrances to title disclosed on the survey. All right. And then right down below it, buyer may object earlier of the closing date, or most people put 7 days here, 3 days, 5 days. It's you and your buyer choose after they receive the commitment. There may be some deed restrictions that nobody told you about. Right, this top blank says prohibit the following use. You know, if you're buying a piece of property and you're wanting to raise pygmy goats on it, you can put that on here. And if there's a deed restriction that says goats can't be on the property, you have however many days you put in this blank to back out, terminate the contract, and receive your earnest money back. Right? You see this more residential, more commercial, but it can be used for anything. Paragraph E is title notices. These are things, again, this is items that the buyer and the seller are agreeing to. So if they want to take time to read it, let them read it. Or maybe read it to them, or at least be able to hit the high points in it. Abstract or title policy. Broker advises buyer to have an abstract of title covering the property examined by an attorney of buyer selection. You as a realtor, me as a broker, we are not attorneys. We do not offer legal advice. We do not make legal decisions. If there are concerns or questions that go into that field, recommend for them to speak to the attorney of their choice. Never practice law. Not going to work, not going to happen, and you're going to get in trouble for it. 2, membership in a property ownership association. Right, property is or it is not. If it's not, great, roll on. If it is, you need to go through this. There is a separate form to fill out to provide the information to the homeowners association. You have to provide bylaws, you have to provide the fee schedules, you have to provide all of that stuff to them. There's an addendum for property subject to mandatory membership. Make sure you're using that form also if it's part of a property owners association or a homeowners association. We have to disclose any statutory tax districts that the property is in. Right? If the property is situated in a utility, other statutory created district providing water, sewer, drainage, flood control facilities and services, we have to disclose that to the buyer. Tidewaters, here in East Texas, don't have these, but we do have tidewater areas in Texas. So if you are in an area close to these, the ocean, the bays, you need to be very familiar with tidewaters and the conversations and the forms that have to be used with that. Annexation. Is your property part of an ETJ? Extraterritorial jurisdiction, right? There's areas just outside the city limits that are considered what they call ETJ that could be annexed in. Again, if you're working in that area, it needs to be disclosed. There's maps out there. You can go talk to City Hall. You can get online. There's maps of the ETJ depending on where you're at. The city may be more active in there than others. I know Tyler right now is super active in their ETJ, and there's a lot happening with it. We have some ETJ here in Henderson. Not much going on with it, but it is there. It is the possibility, and we need to have that conversation. Could your property you're buying to build your dream home be annexed into the city limits? Possibly. You're part of the ETJ. It could happen. Paragraph 6 is property located in a certified service area of utility service provider. Again, every area is different. Even towns here in East Texas, it just depends on exactly where you're at, depends on what's going on. This is where you have to be a local market expert. You need to know what's going on. You need to know what options are available. You need to know what service areas are, right? Groundwater conservation is one. If you're in Rusk County, you're part of a groundwater conservation district. Not talked about, it's bypassed most times in conversation when we're talking to buyers and sellers, but it is there. Without having the conversations, doing the research, studying, you're going to miss that. So need to be up to date on that. Public improvement districts, transfer fees, propane gas system service areas, notice of water level fluctuations. If you're on a lake, right, your property goes to the lake edge. Well, drought year, you have more property. Flood year, you have less property. Again, you have to have the conversation. Certificate of mold remediation, if remediation for mold has been done at some point on the property. And then required notices. Are there any notices that aren't discussed in these that we need to disclose to the buyer? Property conditions. This is another section that we blow through real quick. We acknowledge, but we don't spend a lot of time talking about. As we see the market kind of shifting, and as we see more foreclosures, bank-owned properties, REOs, that type of stuff, this does come in play. If you look at their contracts, they have their own contracts, and they specifically address this. But access, inspections, and utilities once we're under contract. Seller shall permit buyer and buyer's agent access to the property at reasonable times. Right? I can't be mad if they won't let me in at 2 o'clock in the morning to do an inspection. It has to be in reasonable time. But buyer may have the property inspected by inspectors selected by them and licensed by TREC or otherwise permitted by law to make the inspections. Right? Any hydrostatic testing must be separately authorized by seller. But that very last line here, let me highlight it, it won't. Seller, at seller's expense, shall immediately cause existing utilities to be turned on and shall keep the utilities on during the time this contract is in effect. So, by no alterations of this contract, by not redlining this and striking this out, if a seller signs this contract as is, it's grandma and grandpa's house, nobody's lived in it in 3 years, all the utilities are shut off, buyer wants inspection. The way this reads is the seller is committing to having utilities turned on for the term of the inspection period. People miss it. People have no intentions of turning it on, or they can't be turned on, but yet they don't redline this section of the contract. Right? Whether or not utilities being turned on for inspections is going to help. It's going to be a better inspection, but sometimes they can't be turned on, and as your seller's agent, you need to make sure of that and make sure that they're not committing to turn something on, to making sure all the utilities are not on. So that one little section, that one little sentence tucked at the end of 7A, it is there. It's in every one of these contracts, so it's there. B, seller's disclosure notice pursuant to 5.008, right? They have received the notice. Everybody is required, almost everybody is required to provide a seller's disclosure. Whether it's the 3-page form or the 7-page form, it's talking about what the property has, what it doesn't have, what works, what doesn't work, issues that need to be repaired, repairs that have been made, inspections that have been done, what type of homestead on it, is there flood insurance, right? There's a whole mess of information, and there are a few exceptions that don't have to do the seller's disclosure, but most of the time it has to be done and it has to be provided, right? The first box is if they've already received it, right? They pulled up the MLS, they pulled the associated docs, they printed off the seller's disclosure, they've already provided it to the buyer, buyer initialed it, sent it back with the offer. You would use 1. Paragraph 2 is they have not received it and they put how many days. I'm going to put 3 to 7 days in this field because I want a copy of that while I'm still in my option period, my right to terminate period, in case there's something there. It had foundation work, roof was replaced, water leak, whatever that is. So I'll put 3 to 7 days here depending on what it is. Or 3 is the seller's not required to furnish the notice under Texas Property Code. If the house was built prior to 78, they have to provide a lead-based paint addendum. An acceptance of the property condition as is means the present condition of the property with any and all defects and without warranty except for the warranties of title and the warranties in this contract. So buyer accepts the property as is. Now, by selecting the buy property as is, this does not mean that during your option period, during your unrestricted right to terminate, you get your inspections done and there's something there. That does not mean you can't go back to the table, you can't renegotiate, you can't ask for repairs, but you're agreeing to go under contract, all of the terms of the contract with the property as is. If there's some repairs or something that needs to be done, flooring in the kitchen got tore out and they're agreeing to fix that, that's where you'll put here. Buyer accepts the property as is, provided seller at their expense shall complete the following specific repairs or treatments. You can, if you know there's a couple of repairs, you can do it at that point. Paragraph E is lender required repairs and treatments. This is on a finance deal, the lender will usually require an appraisal. The appraiser can come back and state that there are repairs required for approval of the loan. That's what this section E is talking about, unless otherwise agreed upon in writing. Unless you decide you're going to do any repairs no matter what. Neither party is obligated to pay for the lender required repairs. But the second little line down at the bottom, it says if the cost of the repairs, the lender required repairs and treatments exceeds 5% of the sales price. So let's say the house needs to be rewired and the roof needs to be redone. It's $30,000, $40,000. The sales price of the house is $120,000. The sellers agree, oh, we'll go ahead and do it. Because the repairs is greater than 5% of the sales price, the buyer still has the option, even though the seller is willing to make the repairs, to terminate the contract, and their earnest money will be refunded back to them. Paragraph F is one that I don't necessarily point out and read every time, but it does come into play a lot, right? Completion of the repairs and treatments. Right, unless that it's agreed upon prior to, seller has to complete all agreed upon repairs and treatments prior to closing date and obtain any required permits. But the next line, the repairs and treatments must be performed by persons who are licensed to provide such repairs and treatments. Just their handyman that helps them around the house can't do electrical work. It has to be done by a licensed professional in that field. And they have to provide completion and receipts to the buyer prior to closing that repairs were done by this person. Paragraph G is environmental matters. H is whole residential service contract. You also hear called home warranty. This is not home insurance. This is a home warranty program offered by a third-party vendor. It's negotiated a lot inside the contract, but the buyer may purchase a residential service contract. If buyer purchases it, you can negotiate here. Seller shall reimburse buyer at closing for the cost of the service contract in the amount not exceeding. This is negotiable. $500, $675, $950, depending on what home warranty you're trying to use, what package, what program. It's up to not to exceed this amount. So if you have $675 in here, the home warranty is $900. They're only going to pay $675 of that. And the other way, if you have $900, you purchase a $600 home warranty, you're not going to get that extra $300. They're going to cover the cost of the home warranty, and the rest the seller is not responsible for. Paragraph 8 is where brokers and sales agents have to disclose. Texas law requires a real estate broker or sales agent who is party to a transaction or acting on behalf of a spouse, parent, child, business entity in which they're 10% owner or more, or a trust in which the broker or sales agent acts as a trustee. We have to disclose that. I flip a lot of properties. If I purchase a home, I sell the home. In this contract, I have to disclose that as the licensed broker of the transaction, that I am owner or partial owner, or it's my family member that I am representing. Has to be disclosed here. And then paragraph B of 8 says broker fees. All obligations of the parties for payment of broker fees are contained in a separate written agreement. The commission, we'll get to it when we get to paragraph 12. Commission is negotiable, but it is also set in a buyer representation agreement. The commission is there. In a listing agreement, the commission is there. So in another document is where the commission is, in a separate written agreement is where the commission is spelled out of how it's going to be done. Paragraph 9 is closing. Right, the closing of the sale will be on or before, and you can pick your date. Keyword there is before. So just because this says today's the 5th of March, say I say it's 30 days, that's a Sunday, so I pick on Monday, 4/6. This contract has to close by April 6th unless we amend the contract. We have to work towards that date, but this contract allows us to close earlier, right? The closing of the sale will be on or before whatever date you choose, or within 7 days after objections made under paragraph 6D have been cured. This is talking about the title commitment with the extra 15-day automatic extension if there are curative items on the title commitment that have to be done. All right. At closing, these are the obligations that this contract puts on our sellers and buyers. Right. At closing, sellers shall execute and deliver a general warranty deed conveying title to the property to the buyer, showing no additional exceptions to those permitted in paragraph 6. They have to furnish tax statements and certificates showing no delinquent taxes on the property. The property has to be clear of all encumbrances. Paragraph B2, buyers shall pay the sales price in good funds acceptable to the escrow office. Right. A closing is defined as all documents are signed and funds have been transferred. That is closed. There will be no liens. Private transfer fees will be the obligation of the seller unless provided otherwise in the contract. Transfer fees assessed by the Property Owners Association, HOAs, POAs, are governed by a separate addendum, the addendum of property subject to mandatory membership. Number 10, section 10, possession. Right, buyer's possession. Seller shall deliver to buyer possession of the property in its present or required condition, ordinary wear and tear, accepted upon closing and funding or according to a temporary lease. So if the buyer is going to move into the property earlier than closing, or the seller is going to stay in the property after closing, a separate written agreement, leaseback, either a buyer leaseback or a seller leaseback, temporary leaseback, is required signed. If one of those two things happen and you don't have a separate addendum to address that, it creates a tenancy at sufferance. So again, go back, know those different situations. But if they're going to move in before closing or a seller's going to stay after, you need to use a separate form. This box has to be checked. Paragraph 11. Special provisions. This paragraph is intended to be used only for additional information items. An informational item is a statement that completes a blank in a contract form, discloses factual information, or provides instructions. Real estate brokers and sale agents are prohibited from practicing law. You're going to hear that over and over and over. This is not where you put different new terms in a contract that aren't here. This is for factual statements only. If you have questions trying to decide if it can be put in here, not put in, get with your broker. Have a conversation. Don't guess on special provisions. You're not an attorney. Don't act like one. Paragraph 12. 12A specifically is confusing to a lot of people. It's confusing to a lot of agents. It's confusing to a lot of brokers. When commission structure changed, the way the commission reads, the way it is on our listing agreements, this has stumped a lot of people. So the following expenses must be paid at or prior to closing. So 12A1A. These are default items the seller shall pay. Seller shall pay the following expenses: releases of existing liens, prepayment penalties and recording fees, release of seller's loan liability, tax statements, certifications, preparation of deed, 1/2 of the escrow fee, brokerage fees that seller has agreed to pay, and other expenses payable by seller under this contract. All right. So those default every transaction, unless something is redlined, seller is committing to pay those. 12AB, the following amount to be applied to brokerage fees that buyer has agreed to pay. Either a dollar amount or a percentage of the sales price. This is in regards to commission. So when you call, you set up a showing, you've got your buyer representation agreement, you've got that you're getting paid 3% commission by the buyer. In the buyer representation agreement, again, watch the video, but it specifically says in that we're going to attempt to collect our commission from the sellers first. But the buyer, at the end of the day, is committed to pay that commission. When I call to set up a showing appointment, I'm going to ask the agent, are you offering a BAC, a buyer agent commission? Yes, we're offering 2.5%. Okay, so what that is telling me, or if somebody calls and asks me what I'm offering, I'm going to tell them whatever's on my listing agreement. When I took my listing agreement, I had the option to take 6% commission. I'm offering 3% to a buyer's agent. Box below that allows me to market that to other agents, tell them that we're offering that. So depending on what BAC they're offering, depends on what I put in this box. This is, if they're offering 3% commission, and that is what is on my buyer representation agreement, that's the maximum I can get paid, nothing is going to go in this blank, because it's going to be done on a separate form, a compensation agreement between brokers, because an outside document has already created the commission structure. Now, if it's 2.5%, I want them to, I'm going to ask the sellers to pay that additional 0.5% that's on my buyer representation agreement. I'm going to check this and I'm going to put 0.5%. 2.5% from the buyer agent commission from the BAC, plus another 0.5% in paragraph 12A-B. If they're offering a BAC and it matches what your buyer representation agreement says, this will be blank. This is not a default field to put whatever the commission is. This is above and beyond a buyer agent commission that's being offered. 12A-C is what we call seller concessions, an amount not to exceed whatever this number is to be applied to the buyer, to other buyer expenses. This is where seller concessions gets added. If they're needing help with their down payment, they're needing help with closing costs, offering $200,000 but need $5,000 in seller concessions, that is where that would go on the contract. Buyers shall pay the following expenses. Now we're in 12.2. This is what the buyer is committed to paying. This is what the seller concessions can go towards, but this is what is going to come on the buyer side of the HUD or the CD. Right? Appraisal fees, loan application fees, origination charges, right? Whole list of things. Also, there are certain closing fees that a VA and an FHA loan don't allow the buyer to pay that the seller has to. That is spelled out in this portion. Right? And then B says if any expense exceeds any amount expressly stated in this contract for such expense to be paid by a party, that party may terminate this contract unless the other party agrees to pay such excess. Paragraph 13 addresses taxes. Understand what proration of taxes are. You studied it when you were studying for your real estate exam, but understand how prorations work. Right? The seller is going to be responsible unless agreed upon in a separate agreement. Seller is going to be responsible for the taxes from January 1st to whatever day they close. Buyer will be responsible for from that day to the end of the year, depending on if it's the front end of the year or the back end of the year. If the tax statements have gone out, sometimes that money will be credited from the buyer to the seller, and the seller will still pay the whole year taxes, or vice versa. It'll come from the seller, the buyer will get a credit, taxes will be expected to be paid by the buyer at the end of the year. That's what we're talking about with tax prorations. Paragraph 14 is casualty loss, right? Talking about what if something happened to the home while we're under contract, if it was damaged or destroyed by fire or other casualty after the effective date of this contract, seller shall restore the property to its previous condition as soon as reasonably possible, but in any event by closing day, right? Time is of the essence comes into play. Protects both the buyer and the seller in event of a casualty loss. Paragraph 15 talks about default. What happens if somebody defaults? Now, if buyer fails to comply with this contract, buyer will be in default. The seller may enforce specific performance, such as other relief as may be provided by law or both, or terminate the contract, receive the earnest money as liquidated damages, thereby releasing both parties from this contract. take a second, go back and read that statement. So if buyer fails, and then we're going to turn right back around and talk about if seller fails, seller will be in default. Same exact statement. Enforce specific performance, force them to sell the house, seek such other relief as may be provided. B on both sections says terminate this contract, receive the earnest money, thereby releasing both parties from this contract. So if you've got somebody that's in a dispute, they have issues, again, we're not lawyers, we can't give legal advice, but they do need to understand that if they are in that situation, if they sign a release and a release of earnest money and termination, and either party accepts that earnest money back, all liability is released. There's no other performance that can be pushed to make something happen once that is done. Paragraph 16 is another one that people just kind of skip over, and it's mediation. Right? It's the policy of the state of Texas to encourage resolutions of dispute through alternative dispute resolution processes such as mediation. This contract is going to push them to attempt mediation before it goes to full legal process. Not saying they can't use it, not saying it won't go there, but it is agreeing that they will attempt mediation before anything else happens. It talks about 17 the attorney fees, and if whoever prevails, they have the ability to recover reasonable attorney fees. Number 18 is talking about escrow, right? Who is escrow? What happens in escrow? Escrow agent is not a party to the contract, does not have liability for performance or non-performance. They're not liable for interest on the earnest money. They're not liable for the loss of any earnest money caused by the failure of any financial institution in which the earnest money has been deposited, unless the lending institution, the financial institution, is actually acting as the escrow agent. Right? Talks about expenses in 18B. At closing, the earnest money must be applied first to any cash down payment, then to buyer's expense, and any excess refunded to buyer. If no closing cost, escrow may require a written release of liability of the escrow agent from all parties before releasing the earnest money. Right? And then it talks about demand. If you run into a situation and people are fighting over who gets the earnest money back, C talks about how you can issue a demand letter if the other party will not sign the release of earnest money. This is what the title company uses to be able to still release earnest money if you're tied up in a dispute. It's spelled out in this, just as well as damages in D, notices in 19 talks about representations. All covenants, representations, and warranties in the contract survive closing. Just because you close doesn't mean your hands are washed of this transaction. All representations that you made, covenants, warranties that were made during the process, they survive closing. If any representation of seller in this contract is untrue on the closing date, seller will be in default. Unless expressly prohibited by written agreement, seller may continue to show the property and receive, negotiate, and accept backup offers during the time that this property is on the market. Federal requirement, paragraph 20, this is pertaining to IRS and foreign persons. All right, if seller is a foreign person, is defined by the Internal Revenue Code and its regulations, or if the seller fails to deliver an affidavit or certificate of non-foreign status to buyer that seller is not a foreign person, then buyer shall withhold from the sales proceeds an amount sufficient to comply with applicable tax laws and deliver the same to the IRS, together with appropriate tax forms. Title takes care of this on transactions that run through them, that title policy is issued on. If it's a cash deal you're doing outside, get with your broker before you do anything like that. But there are ramifications if you don't withhold from foreign person for the IRS. 21 is notices. All notices from one party to the other must be in writing and are effective when mailed to, hand delivered, or transmitted by fax. Electronic transmission as follows. So many agents don't fill out these fields, right? And the most common reason I get to why they don't is, well, I don't want the other agent or the buyer to have my seller's contact information. They can't reach out to them. That is a breach of confidentiality, a breach of contract. But this is what allows lenders, title companies, us to reach out to our people. It gives us their address, their phone number, and their email to make sure any communication that throughout the contract it references paragraph 21 where it'll be sent. This is where it will be sent. Fill this out, have the information here for effective communication and to assist with making sure we're making our dates, making all the obligations inside the contract. 22 is agreement of parties. This contract contains an entire agreement of the parties and cannot be changed except by a written agreement. Addenda, which are a part of this contract, are all of these are just scratching the surface of the forms that could possibly be necessary to be used with our contract, right? Third-party financing if it's being used, seller financing, right? Sale of other property if it's going to be contingency. Here's the reservation of oil and gas that we talked about. Is it a backup offer? We use the addendum concerning right to terminate due to lender's appraisal. Intermediary relationship notice is one that we add. This is made where you can add whatever addendum you're going to be using that's not in our list. Everything that will be used in the contract needs to be checked. If it's not on the list, again, add it here. Consult an attorney before signing. If they have an attorney, they've told you they have an attorney that's going to review everything, I'm going to put their info here so the title company can send that to them. But if not, seller's choice, buyer's choice, I want them to understand. It gives me the opportunity. Again, if you have questions, please reach out to an attorney if they're legal questions. I can't practice law, but you have the right to have an attorney review or look at anything that you're signing or you're agreeing to. The next page is a signature page, and then you have the executed box. This contract is not executed until everybody has signed and this date has been populated inside that box. Now, once it is executed, changes can't be made to this contract. You have to use an addendum, an amendment. You have to use a different form to alter this contract in any ways. If a buyer fills this out, they sign it, they send it over as an offer. At that point, it's an offer to your seller. Once the seller reviews it, if there's no changes, they can initial their sections of each page, sign here, and it can be executed. But if they make any change at all to this contract, because there's another contract that there's a video of called the unimproved property in the farm and ranch that require a seller's disclosure to be filled out by the sellers, right? If it's left blank, they send it over and my sellers make a change, I cannot execute this box without sending it back to the buyer for them to initial the changes before it's executed, because I've altered the offer, so I didn't accept it as is. So until everything is complete, everybody is assigned, everybody has initialed, that point this can be executed, copies sent to all parties, title company and lender if lender involved, to start the process. The last 2 pages, this one is for the broker information. This is printed names only, do not sign. This is an information page. This is who is representing who. Right? We've got buyer only as buyer agent, seller as listing agents, sub-agent. We don't do sub-agency here anymore. So buyer only, and then we have seller only. If you have 2 different agents from 2 different organizations, you would have the buyer on the left side, right? Broker name, license, associate name, license, email, phone number, supervisor or broker, their license number, contact info, and then on the right side, you would have the seller side. If it's you representing both sides as an intermediary, or it's 2 people inside your office, you're still being represented as an intermediary. Because understand, any document you sign, any form you sign, you're signing as a representative of your broker. All agreements are between the buyer and the seller, the clients, and the broker. So if I have one agent that's representing the seller and I have another agent that brings the buyer, I am as broker representing both parties, and we are functioning underneath an intermediary status. If that's the case, nothing would be on the left side. This side would be completely blank. We would select seller and buyer as intermediary, and both parties would go here, right? Agent one underneath me as I'm their broker, agent two that's representing the seller, and then you have this little part down in the bottom. Let's make commission even a little more confusing. Disclose pursuant to a previous separate agreement, listing agreement that the selling agent took, buyer representation agreement that the buyer's agent took when they started showing property. These are your separate agreements. Listing broker has agreed to pay other broker a fee of. If I call and they tell me they're offering 2.5% in buyer agent commission, this is where this would go. Now understand, this is not binding. This is for informational purposes. And it says the disclosure is for informational purposes only and does not change the previous agreement between brokers to pay or share a commission. So if I took 3% on my buyer representation agreement, they're offering 2.5. I'm going to put 2.5 here. I'm going to fill out the additional addendum, the compensation agreement between brokers for 2.5, and then back up in paragraph 12(1)(b), I would have put the additional 0.5% coming from the seller. So I'm asking for the 2.5 that I'm getting from the listing agent, the listing broker as BAC, and I'm asking for an additional 0.5% from the seller to equal the 3% that I put on my buyer representation. Then the last page is the receipt page. Right, this is what's attached to it. The title company or the escrow officer or the attorney, whoever's acting as escrow, will fill this out, send it back to us, and we keep copies of it. Right? You've got option fee receipt, earnest money receipt, contract receipt, and any additional earnest money receipt. So again, print this out, take the time, read through it, learn it, write down your questions. You're not going to get better, you're not going to get more comfortable if you don't practice going through it, right? Skill drills, role play, practice presenting this to people. You're going to feel like you're just rambling a ton of information, and there is a ton of information in this, but we need to be comfortable with it. We have to be content experts. We can't answer questions if we've never read it ourselves. So take the time, work through it, write down your questions, grab your broker, grab a veteran agent, grab a training video, and get familiar with this contract. This is the most used contract that we use. You will interact with this. You need to be comfortable with it. So again, appreciate the time. If you have questions, reach out. Look forward to the next video. Y'all have a great day. If you enjoyed this video and would like to learn more about the real estate industry, please hit the like button and subscribe to the channel.